All right, guys. David Miller here with David Holmes, attorney. Um, doing our interview just a little different today, and going to talk with you about something that I'm not really well versed in. David is. We'll preface like we did before. David is not the only attorney that we use and point people to, and we're not the only real estate professionals that he works with. David's located in Slocomb, Alabama, and knows real estate law really, really well. So thank you for taking a little time today, David. What we're going to talk about is dying with a will or without a will, and say you own property, you own your house or you own property. And David's going to kind of go through the scenarios, and I'm going to try to, like I said, I'm as ignorant to this as I am anything, but we're going to let David explain it, and hopefully this will help you guys understand a little better, because I need to learn it and probably rewatch this. So, David, say I pass away and I do not have a will. Say I'm 36 and I own my house and I pass away without a will. I know there's a lot of variables there. You can kind of navigate that for us. Can you paint that picture for us, what that looks like?
Yeah, let me preface it by saying that every person's situation, particularly in this case, is probably going to be different. So they're going to need to speak to their attorney about planning and about the situation of their affairs as they exist now. Obviously, this is one of those cases, if you wait till it happens, it's too late. Everything's locked in. Yeah. But let's just speak generally in two situations. Let's look at a situation where it's a husband and wife, and they bought their property, or all the property they own, their real estate, is in joint tenants for right of survivorship. If that happens, then all the surviving spouse has to do is record a death certificate of the deceding spouse. Property has automatically transferred over. Probate, in reality, is for creditors. There's a statute in Alabama, and I can find it for you, but I can't tell it to you off my head, that says upon the death of a person owning property, that their assets, so their real property, passes to their heirs at that time, subject to claims of creditors and subject to being redirected under a will. Right now we're talking about no will. If a person dies with no will, let's assume for a moment everything's not joint tenants for right of survivorship, because that makes everything easy. That's a cheap, easy planning prospect that I recommend to all parties. However, if you die and you don't have a will, and everything is not joint tenants for right of survivorship, or perhaps you're not married, then the law says if you are married, half of everything you own goes to your spouse, the other half goes to your lineal heirs. Now that's a fancy word for saying children. So in reality, your spouse, although she may have participated in buying the property and everything else, if it's not in her name or she's not on your deed, half passes to her and half passes to your children, assuming you have children. Now, if you have minor children, then that figure becomes half plus, I believe, $50,000. Differs between states. I think Florida is $100,000. The concept there is the spouse is going to need to raise those children, so she actually gets more than just the half. But in any event, that's what happens. Now, an estate can still be probated even without a will. It's called an administration. Right. It's a lot more technical. It's a lot more what the court says and less what the will says, and because there isn't one. So, you know, in every case now, although I don't particularly agree with it, every case now, the local probate courts are requiring a bond to be posted if there's not a will. That's an expense that can be gotten around by doing a will and providing in there that no bond should be required. If you wanted somebody to have a piece of property and you don't do a will, unless they're one of the heirs at law that it's going to pass to, your choices are not going to be followed. It's going to be based on Alabama code.
Right. So that's dying without a will. Dying with a will, I'm going to put it my way and then you can correct it. Dying with a will, my understanding would be basically I can direct how I want my assets to go when I pass. You still have to probate the estate with a will, and basically probating the estate is 6 months of calling everybody or checking and making sure nobody says, hey, he owed me money, kind of thing, right?
Right. What happens is when if let's assume there is a will. If you file for probate and you have to send a notice by certified mail to every known creditor. That means if you're going through the person's affairs and you find a credit card bill or a bill for some particular service, you have to send that party notice by certified mail. In addition to that, in every case, you have to publish once a week for 3 weeks in the local newspaper an announcement that there is an estate being opened and any creditors have the opportunity to come forward and file a claim against the estate. From that period, when the estate is opened and the court admits the will to probate, creditors have a 6-month period in which to file their claim and seek to get paid from the assets of the estate. Get paid before beneficiaries get their assets. In addition to that, it can be directed who you want to be the personal representative, so who you want to handle your affairs, whether or not you want them to have a bond, whether you or not you want them to have to file an accounting with the court. All of those things can be provided for in a will. And perhaps the most important factor is that a will can be changed at any time, right up to the time you die, as long as you remain mentally competent. Now, needless to say, if you're on your deathbed and you're under, multiple units of morphine and things like that in a hospice type situation, the credibility of that will is probably going to be challenged. But if you leave, and this happens frequently, actually, I've got about 3 on my desk right now. If you prepare your estate plan and then 5, 10, 15 years pass by and things change, maybe a child dies, maybe one child's proven to be less responsible and you've made them the personal representative, then you can always change those things. You can completely redo it. In an estate, all that's going to be done based on Alabama code. If you're in Alabama, Florida statutes, if you're in Florida, of course. And those are the only 2 states I practice in, so I'm not going to venture a guess of what might happen in Louisiana or Georgia. But the thing is, you have control with a will. Now, probate, everybody seeks to avoid probate. Probate is a reasonably expensive process. But at the same time, not having a will and not having a will that can be probated, just because you have a will doesn't mean it's not going to have to be probated. A will's not good until it's submitted to probate by the court. And just not having a will also doesn't mean that it's not going to have to be probated. So, you can do things to attempt to avoid probate, which are, going to take us far beyond the time period we have here, which is why I suggest before you do anything, sit down with an attorney and learn what your options are. Yeah. Second marriages, what I call yours, mine, and ours situation, where my spouse has children, I have children. If we put everything as joint tenants with right of survivorship, then if I die, it all goes to my spouse. If she dies, it goes to her children. My children are inadvertently left out. So that may be something you want to evaluate. That actually happened to me, which I couldn't have been happier with because I'm very close with my stepmother, and she frankly was married longer to my father than my mother was. But in any event, those are things that you need to go and evaluate with your attorney about. This is what I've got. this is how I want it to be dealt with. How should I deal with it?
Right. Well, and what we've run up against as in real estate, whenever I hear that an estate has not been probated, I automatically jump to, well, we can't sell the house for 6 months, but that's not always the case. If an estate, I guess if they've got enough assets or if their attorney advises, you can sell a property, proceeds will go in escrow. What determines whether that's able to be done or not?
We'll talk two situations, one where there's a will, one where there is not a will. Let's talk about the will first. The will's been admitted to probate, but the 6 months hasn't been run. The will very well may specifically say in it that it gives the personal representative, and what some of us older lawyers may have known as executor or executrix, gives them the power of sale. If it gives them the power of sale, they can sell that property within the 6 months. They just can't distribute the money that comes from the sale of that property. And so there has to be an escrow agreement, because if a creditor comes in 5.5 months later and they're a large creditor and the assets are necessary from that sale to pay it off, and the personal representative distribute that money, that personal representative is going to have a real problem on their hands. So it needs to be held in escrow. As the buyer of that property, you want to be assured it's held in escrow. Frequently, you'll leave it in the attorney that closes the deal, let him hold it. There's any number of ways of doing that. If you handle that period, of course, is going to run, if it hadn't been admitted to probate, it's going to run 2 years. If it has been admitted to probate, there's no inherent right to sell, but you can, and we're fortunate, at least in this county, that we have a pretty responsive probate judge. You can file a motion to sell that property with the court, explaining to the court that it needs to be sold. You have a contract. This is the contract. It's a fair contract. Everybody agrees, or it's for a reasonable amount. If everybody agrees, the judge frequently will sign off and restrict that it cannot be distributed until such time as the period for creditors is run. Now, there's one third situation that we have in Alabama that's a little different, that we hadn't talked about, and that's that there's no probate. And all of a sudden, the kids get the property. Mom and dad have died. They died 5 years ago. If it's more than 2 years, the claims period for creditors have, if there's not a probate, creditors have up to 2 years to come in and start a probate. If that 2 years runs, creditors' claims are eliminated. And then the children or whoever inherited it, going back to what I said about the statute saying that it passes upon death, whoever it passed to under the law can then sign a deed conveying that property, even if there wasn't a probate. Takes a little bit of some recitations about who the sole heirs were and things like that, but it can be done. So that's one prospect. If it's within that 2 year period, an attorney is not going to be able to give a lender a clear title opinion until that 2 years runs. So the sale might could take place under certain circumstances, but if there's going to be a financial institution involved, it probably is not going to take place.
Gotcha. A lot of moving parts, and I like to talk real simple, but you have to get more specific, because I'm always able to pass the buck to an expert on that. So, but that's been helpful, man. I hope this is interesting for everybody viewing. If you got more questions, obviously, like David said, everybody's case is different. Whether you've got, if it's just you and you pass away, it's just different. Everybody's situation is different. So when it comes time, like he said about a will, it's too late. If it's too late, it's too late. So encourage y'all to speak with an attorney or David and get that in the works. Anything else, David, you want to say or clarify?
Well, I could talk all day, and there's year-long law school classes that talk about these things, and we could take every subject we've talked about, and I could probably break it down into an hour to 2 hour discussion, which is beyond the scope of this.
Yeah.
So that's a general, very, very general, very, very highlighted version
Yep.
And that's, I think I've said this 2 or 3 times, but I'm going to say it. I said it in opening. I'm going to say it in closing. Talk to your attorney about what you need to do.
That's right.
Because
That's
every case is going to vary.
Good deal. Well, man, I appreciate you taking the time today. Like I said, David has been in Slocomb, Alabama on Highway 52. That's where he practices. How long you been in Slocomb again? You tell it pretty
I've been in Slocomb for 35 years.
He's been doing it and does a lot of closings for us, and enjoy every closing we got. Got a good office staff there, and they process them well. So, man, thank you for taking the time again, David. Y'all have a good day of it.
Our pleasure. Stay safe.
Thank you, man. Take care.